is right here.
Good morning, ladies and gentlemen. I'm Lucky Heggs, Vice President of the Colorado Motor Vehicle Dealer Board. I'm presiding in the absence of the Board's President, Steve Perkins, who was unable to attend today. Today's meeting is October 25th, 2018, and the time is 9:04 a.m. These proceedings are being recorded as part of the standard process of the rulemaking by the Board. I've determined that a quorum of the Board is present, so it's possible to proceed. At this time, I'd like to call for a motion to open the hearing to consider proposed rule revisions and proposed new rules related to both 1 CCR 205-1 regarding motor vehicles and to 1 CCR 205-2 regarding power sport vehicles. The Board will consider both proposed revisions and deletions of existing rules and also proposed new rules. The Board will specifically consider proposed revisions of the following rules. Motor Vehicle Rule number 44-20-10220, Motor Vehicle Rule number 44-20-1081E, Motor Vehicle Rule 44-20-1092, Motor Vehicle Rule 44-20-110, Motor Vehicle Rule 44-20-120, Power Sports Vehicle Rule number 44-20-4092, and Power Sports Vehicle Rule number 44-20-4191. The Board will also specifically consider proposed deletions of the following rules. Motor Vehicle Rule number 44-20-10228 and Motor Vehicle Rule number 44-20-1081HI. Additionally, the Board will consider the following proposed new rules. Power Sports Vehicle Rule number 44-20-4028, Power Sports Vehicle Rule number 44-20-4081F, and Power Sports Vehicle Rule number 44-20-410. Is there a motion to open the rulemaking hearing?
I, Michael Whithelm, as a member of the Motor Vehicle Dealer Board, pursuant to the authority of the Board and the Colorado Revised Statute Section 44-20-104(3)(a) and 44-20-4041A, to promulgate, amend, and repeal rules pursuant to the provisions and proceedings in and arising from Colorado Revised Statute Section 24-4-103, move that the Board open and conduct a rulemaking hearing on the proposed new and revised rules and the proposed deletions of current rules that were given public notice by publication in the Colorado Register, Volume 41, Number 18, on September 25th, 2018, under tracking numbers 2018-00474 and 2018-00475, and as set out in the record for Board review for this October 25th, 2018 rulemaking hearing.
Is there a second?
Second.
Second by Mr. Flower. Is there any discussion? All in favor? It's a unanimous decision. The motion to open the rulemaking hearing passes. The formal rulemaking hearing is now open. The hearing will proceed according to the provisions of the Colorado Administrative Procedures Act, specifically sections 24-4-103 of the Colorado Revised Statutes, and according to other relevant provisions of law, regulation, and policy. Today's rulemaking hearing received official public notice on August 25th, 2018, by means of publication in Volume 41, Number 18 of the Colorado Register. Public notice for rules found in 1 CCR 205-1 related to motor vehicles is under tracking number 2018-00474. Public notice for rules found in 1 CCR 205-2 related to power sports vehicles is under tracking number 2018 00475. Supplemental public notice occurred by publication on the websites of the Department of Regulatory Agencies and the Auto Industry Division of the Department of Revenue. It is important to note that today's rulemaking hearing materials are being provided under the statutory framework of Title 44 of the Colorado Revised Statutes because the former Title 12 statutory framework ceased to have legal effect for board actions, including rulemaking hearings, occurring on and after October 1st, 2018. The board's rules were also non-substantively recodified from the Title 12 framework to the new Title 44 framework, effective also on October 1st, 2018. Therefore, the board will conduct its review and make its determinations today on the rules as recodified into the Title 44 framework. The rulemaking hearing materials contain references to both the statutes and the rules as they were in the Title 12 framework, but merely because the original public notices were presented in the Title 12 framework that was in effect at the time of the notices.
And I'd just like to make a note here for the board and the public. During the stakeholder meetings that were held for this group, this was a point of discussion at the outset of both stakeholder meetings, that it was going to be changed from the Title 12 framework that we were operating under to the Title 44. And that is reflected in what was posted with the Secretary of State's office.
Today's rulemaking hearing offers any interested person the opportunity to make public comments to the board on one or more of the rules under review or to provide additional documents for the board's consideration, or both. The hearing is quasi-legislative in nature, not adversarial. All viewpoints are welcome. Anyone can speak and share information and opinions regarding the rules under review. Anyone who wants to make comments to the board and or to provide additional documents to the board must mark the appropriate yes box beside their signature on the attendance sheet. Right before I open the public comment phase, I'll look over the attendance sheet, add up the number of persons who want to make comments, and determine if there is if the number of persons is large enough to require that each person be limited to no more than a particular number of minutes that I can declare before the first speaker comes forward. The board can, of course, agree to give a given speaker's request to enlarge the time of their presentation. All speakers are urged to make their points as succinctly as possible. The board has before it the record for board review, including the board has before it the record for board review. Included in the record are the following: the current text of each of the motor vehicle rules the board will consider in the rulemaking hearing, along with the red line text version and the clean text version of those rules. The current text of each power sports vehicle related rules the board will consider in the rulemaking hearing, along with the red line text version and a clean text version of those rules. Materials related to each stakeholders meeting, the first of which was held on August 23rd, 2018, and the second on September 11th, 2018. Filing and notice materials related to the Secretary of State's office tracking numbers 2018-00474 and 2018-00475. Filing and notice materials related to the Department of Regulatory Agencies filings under both 1 CCR 205-1 motor vehicles and 1 CCR 205-2 power sport vehicles. Notice of hearing with proposed draft rules to interested parties. Comments from interested parties and the public received after publication of the notice of hearing and through October 21st, 2018. Relevant web published materials by the Auto Industry Division on behalf of the board. The current organic statutory scheme of the board as of the date of this hearing, i.e. under the Title 44 framework, Section 44-20-101, EDSEC, CRS, motor vehicles, and Section 44-20-401, EDSEC, CRS, power sport vehicles. Relevant rule review and rulemaking law, executive orders, and Department of Revenue Department of Revenue policy and supplemental rule making related information publicly provided by the Secretary of State's office, the Office of Legislative Legal Services, and the Department of Regulatory Agencies. Mr. Beebe, a subject matter expert for the Auto Industry Division, will introduce the record in general and then provide the Auto Industry Division's position on each separate rule, taken in turn. The board will then entertain public comments on these rules. The board members may ask the division and any public commenter as to many relevant questions as the board may have regarding any particular rule. After the public comments have concluded, Mr. Beebe will be permitted to comment further as needed on any rule or rules. The board will close the public comment phase of the rulemaking hearing after the public comments and potential additional comments from the division have been made on all of the rules of the board, on all of the rules the board has before it for consideration today. Once the public comment phase has ended, the board will enter into the deliberative phase and will not entertain further comments from the division or from the public. During the deliberative phase, the Attorney General representative will be on hand to continue to address legal concerns relevant to the materials before the board. During the deliberative phase, the board will engage in discussions and deliberate as long as necessary upon the written record for board review, together with any written materials made part of the comprehensive record subsequent to October 21st, 2018, and including any written submissions in the course of the board's hearing today. The board's deliberations will also include the oral comments of the division and of the public made during the public comment phase. The board will deliberate on each rule, in turn, brought before the board in the hearing today. After the board has taken action on each rule, it will close consideration of that rule and open consideration of the next rule on the agenda. The board will repeat this process until it completes consideration of each and takes action on all of the rules on the rulemaking agenda. For each rule, the board will take some action today. The board's options for each rule include, but are not limited to, the following actions. It may adopt the proposed rule as presented by the division, or it may adopt the proposed rule as presented by the division, but with modifications made by the board. Or it may continue deliberations on the rule until a later date that is announced. Or it may reject the proposed rule as presented by the division. It is important to note the following. If the division has presented a new rule, then the board's rejection of that rule means that the rule does not become a rule in the board's body of rules. If the division has presented a revision to an existing rule, or if the division has proposed a deletion of an existing rule, then the board's rejection of the proposed rule means that the rule continues, unchanged in its current form, as a rule in the board's body of rules.
And I'd like to make a reminder for the board at this time. So this public comment phase that we're about to go into, this is your opportunity to ask questions regarding the rules. So feel free to ask questions of Mr. Beebe or any of the individuals commenting from the public regarding the specific rules. It's fine if you ask your questions after they discuss a certain rule, or if you have questions that come up at the end of all the public comments, you can address those questions at the time. But again, the public comment phase is where it's appropriate to ask the individuals that are speaking about these rules questions that pertain to those rules. Thank you.
The public comment phase of the hearing will now begin. Leland Beebe, who is the legal assistant and rules administrator for the Auto Industry Division and the Motor Vehicle Dealer Board, will make the division's presentation of the record to the board. Mr. Beebe, you have the floor at this time. Please proceed with your presentation.
Thank you, sir. As a preliminary note for the board and for the attendees, I have presented to the board members a single entry of a new page to the record. And that new page to the record is a notice for the record regarding written public comment. It reads, between October 21st, 2018 and October 25th, 2018, which is today, this morning, at the time of this meeting, neither the Motor Vehicle Dealer Board nor the Auto Industry Division has received any public comments by mail, email, or facsimile transmission related to any of the board regulations set for review at the October 25th, 2018 hearing. So the record, as written with this single edition, is closed as such. Any additional materials will come in through commentators now. So in my introductory comments, first of all, there's some general comments that apply across all rulemaking hearings like this, and not everyone will have heard these before. Okay, the staff of the Auto Industry Division are pleased to present their recommendations with respect to the rules in this 2018 rule group set of rules. For some board members and others in attendance, this may be the very first rulemaking process in which they will participate. The record before the board always looks daunting. If you were to see it printed out, it is 556 pages long, as of this new additional page. But you should have no fear. It is a required compilation of all of the rulemaking materials that have been part of the process to date and the statutes and standards that frame the entire process. Much may seem redundant when you look at the pieces of it, but that is because it is redundant of necessity. The board is presented with a history of the rulemaking process and of the resources that are used in that process. It's a story. All of the requirements must be available for the board to see, because the board is the deliberative body upon which all that law and regulation rests. Our staff report to you is intended to focus on the regulations under review, carrying forward the drafts as last produced out of the stakeholder meeting, the second stakeholder meeting. The stakeholder group met twice and saw no need for additional meetings. The group reached a consensus on the drafts that you see. That does not mean that a stakeholder could not change his or her mind now or step forward to provide new thoughts and opinions. No one is stopped from that. However, the auto industry staff have not changed their minds. They continue to agree with the regulations as you see them presented. This staff report will proceed using the segmentation of the rules on review that each board member has in front of them. There are 7 segments. The segmentation protocol exists to aid the board's receipt of not only the staff report, but also the comments of the public. It is also a tool to facilitate the board's discussion and determinations in the deliberative phase of the hearing. As I go through each segment, the board can follow along. Each segment presents the rule or rules of that segment, setting out first in each segment the motor vehicle related rules, and second, the power sports related rule. This is probably the best time to inquire if any of the public could use a copy of these segments. This is particularly important if someone intends to comment on a given rule or rules in a segment, or on several rules in several segments. A commenter who has the segments in front of them when they address the board can, as it were, and as I will be doing, refer to the appropriate rule in the segment in which it appears. This is obviously easier for the board. Is there anyone in the public who needs a packet of these segments at this time? Okay. All right. Seeing none, if you should have that need at some point, if you are going to come forward, we do have copies of them and can give you such. Okay. Now let me spend just another minute going over the way the segments are structured. This is again instruction for everyone. Each segment will have some material related to motor vehicles and some related to power sports. The motor vehicle-related materials appear first under the major division letter A. This is to correlate with what you have in front of you in your full board record. The power sports-related materials appear following the motor vehicle-related materials under the major division letter B. Within each of these divisions, both motor vehicle and power sports, are 3 text versions, as Mr. Higgs pointed out. They are always in the following order: the current text version, if such exists, the red line text version displaying any proposed revisions or the new proposed rule in the standard red line format, and finally the clean text version, which is called that because it represents what the rule would look like printed out just as proposed. Now I'd like to turn briefly to those rule drafting considerations that went into the proposed revisions to these existing rules and the proposed language of new rules. The rule language that went through one or more iterations in the course of the stakeholder participation process, but always the stakeholders and the drafters were mindful of the standards that must be used to compose the drafts you now see before you. Important among these standards and considerations are the following. Number 1, relevant substantive changes in the board's authorizing statutes or to the Administrative Procedure Act, in this case, have taken place. There were such changes made during the 2017 and 2018 sessions of the General Assembly that required the drafters and the stakeholders' attention, and which will also require the board's attention in this rulemaking session. Legal restraints on the language of a regulation, principally the following. First, the restraint on scope. The authorizing statute set the boundary of activities the board can engage in. This happens greatly through the express language of a statute. The board is not allowed to engage in actions that exceed the boundaries of the authorizing statute. So there is an ongoing question in the review and in the drafting of rules. That is, does any existing language in a rule or does any language proposed for a rule exceed the scope of the authorizing statute or statutes? If so, that language must be removed or altered and cannot be promulgated as such. Constitutionality. The board is a creature of Colorado state government, operating within the limits of the Colorado and the U.S. Constitution. Board members have sworn an oath to uphold those. The board needs always to be careful not to violate constitutional provisions through its regulations. The third one, overlapping or duplicative expressions. It is important to recognize the legal hazards of including identical or similar provisions in the board's own rules or including in the board's rules provisions that overlap with another agency's provisions. I'm not speaking about language that simply defines a given term identically. The real danger is language that could confuse a member of the public or make them vulnerable to enforcement in one agency, but not in another, for one and the same activity. To prevent such confusion or vulnerability is a research effort that an agency and its stakeholders have to engage in while reviewing and drafting rules. Unnecessary regulation. Rules are not always necessary. If statutory language is sufficiently clear to permit recognition of violations and allow appropriate enforcement against violators, then a rule may not be necessary. The critical question is, does the authorizing statute in and of itself provide sufficient guidance to the public and the agency so as not to be helped by any related regulation? Inadequacy of language to meet policy goals. An agency itself, as well as its authorizing statutes, exists to address certain goals recognized as important by the legislature. These goals often are visible at the beginning of an agency's organic statutory scheme in the form of an expression of legislative intent. The board's organic statutes, both power sports and motor vehicle, begin with multiple objective expressions termed legislative declarations. These are the legislature's vision, if you will, for the body of law that follows. They also supply guidance to the public, the agency, and the courts to assess whether the rules of an agency are lined up with these goals or are either inadequate to address them or may even run contrary to them. Among the goals that come up in any review by the staff, the stakeholders group, or the board are two that are common, which would be consumer protection and healthy business competition. Those are only two of what the legislature has set out as goals. Okay, plain English expression or modern language clarity. Language usage changes across time. What may have been a clear, well-understood expression in 1947 when the board began to exist may be unclear or even worse today. Drafters, stakeholders groups, and agencies, including the board, need to use the best wording of the modern era to compose revisions or new provisions of rules. The Colorado legislature has mandated that as far as possible, the so-called plain English standard be applied. Moreover, the legislature has expected itself in statutes it drafts and expects the agencies in rules they draft to adhere strictly to the modern English language conventions of grammar, syntax, spelling, punctuation, etc. Then the board has what I would consider to be a really unique for an agency consideration that has to be dealt with every single time. Parallel rules need to exist between the motor vehicle related set of rules in 1 CCR 205-1 and the power sports vehicle related set of rules in 1 CCR 205-2. Because in most instances, the legislature has set out identical or virtually equivalent operant statutory language. Therefore, in the stakeholder meetings, the rules were taken up in rule pairs, and that is why the segmentation you have of the rules for this hearing is organized in rule pairs as well. The process is called parallelism. The result, for the most part, is what is known as parallel regulation. This is not a choice, but a necessity imposed by the constitutional principle of equal protection under the law. The board cannot deal with motor vehicle related licensees differently from power sports vehicle related licensees unless there is a substantive basis for a distinction. Occasionally, as you will see in the current set of rules before you, there will be a need to depart from pure parallel structure. Now, as we move to each separate segment with its individual rules, it's worth making several comments that apply to most of these rules. Statutory changes in the last two legislative sessions brought with them not only the change of the statutory framework from Title 12 to Title 44, but also a general cleanup of the old framework to eliminate mention of, for example, deletions and also so-called decimal point statutes. A good hypothetical I thought I'd share with you there is, say you had a statute series 1-10-102.5, the series began 1-10-102, and then the legislature had brought in something that it thought topically fit as 1-10-102.5, and then following that was the 1-10-103. Well, when they clean up things, they renumber. They get rid of all those decimal points because those are a bit confusing. What it does, however, is it creates a serial renumbering, and you see that reflected, when we look at the title transitions from one rule to another, from one statute to another, between Title 12 and Title 44. Additionally, the functional assignments, and this is particular to our agencies, the functional assignments of the Executive Director of Revenue, the Director of AID, and the Executive Secretary of the Board were clarified. Moreover, the designation of certain important terms, for example, quote, motor vehicle dealer, end quote, which means a new vehicle dealer, and, quote, used motor vehicle dealer, which means, just as you would assume, a used vehicle dealer, changed, necessitating careful and consistent use of those terms in the set of rules here. One of the stakeholders pointed out to us in the drafts that were presented in the stakeholders meeting that the draftees had somehow not been consistent with the formulations as they needed to be, and we corrected that. So what you see before you is consistent now with the new definitional framework and consistent elsewhere. Okay. The stakeholder, staff, and the Attorney General representative have endeavored to be accurate and consistent in the referencing and use of defined terms throughout this set of rules. That doesn't mean you might not find something wrong. Please speak up if you do. Okay. I suppose I should say, are there any questions about this general information? Because this would be the time to ask. Okay. All right. So let us turn to segment 1. I'm going to be flipping through several different pieces of paper as I move through this. Bear with me just a second. Okay, segment 1. There are 2 things going on here, as you were told there would be. The one is something about motor vehicles, and the other is something about power sports. So, we're dealing with motor vehicle rule number 4420-102, parent 20, which is a proposed revision to the rule. And also with power sports vehicle rule 4420-402, parent 8, which is a proposed new, similar, but not completely parallel rule. So right up front, you're going to see a distinguished set of rules here from pure parallelism. Okay, now, I would say to you all right now that you are going to hear the longest discourse from me of anything that I'm going to be talking about in this part. And there's a reason for that, which will become clear to you. This was the most discussed rule pair in all of them. And there are good reasons why, and you're going to hear all those now. Okay. This rule pair offered the most challenge to examine reasonable issues as well as the greatest opportunity to propound language that is fair among distinguishable categories of the regulated industry. The statutory definitional language, section 2420-102, parent 20, states, quote, parent new motor vehicle, parent means, not parent, quote, means a motor vehicle that has been transferred on a manufacturer's statement of origin and that has sufficiently low mileage to be considered new, as determined by the board. There are 3 matters needing further definition and delineation in this simple appearing statutory definition. 1, language that is more than an invitation to the board to set some benchmark of mileage to meet the concept of newness for a motor vehicle. 2, the industry term of art, quote, transfer, end quote. And 3, the industry/governmental term of art, quote, manufacturer's statement of origin, end quote. Prior boards, and I mean multiple, have dealt with all 3 of these, as well as other matters in the creation of the current rule based upon this statutory definition. In the initial staff draft of a proposed revision of this rule, the staff and the Attorney General representative had based the draft on almost every one of the necessary considerations set out a few minutes ago. This one needed a lot of looking at. It was safe to generalize that the existing rule exceeded the scope of the authorizing statutory definition, was a hodgepodge of well-intended assertions or exceptions and internal sub-definitions, but was open to confusion and misinterpretation. It had been around, being knocked around, for decades. Plain English was not evident, and the complexities threatened due process with regard to some enforcement actions. The stakeholders agreed fundamentally with the need to completely restructure the rule in the manner of the staff draft. The fundamental bright line for most motor vehicles, that is an odometer reading of 1,500 miles or more, taking the vehicle out of the new category, was still viewed as the appropriate line to draw, but with one possible exception, for something called motor homes. At the initial stakeholders meeting, participants raised concern that motor homes are a uniquely separate type of motor vehicle. Unlike their automobile counterparts, motorhomes are not usually transported on or by truck or train from the manufacturer's factory to the dealer's door. They are driven. Their transit is most of the time on the road, and that adds upfront miles to the motor home. On the basis of initial discussion information, the stakeholders group became aware that a motorhome could, conceivably, here's an example, be built more than 1,500 miles from a Western Slope RV dealer that took delivery of the vehicle, that vehicle having been driven the whole distance to the dealership. So there could immediately be the fact that somebody just came out of the factory days before, has gotten to the dealer on the western slope of Colorado, and is now going to be declared by the current existing rule not to be new. Okay, that was news. Okay, thus coming out of the first stakeholder meeting, the staff and AG drafters were charged with making an exception for motorhomes by setting a higher mileage threshold to allow the necessary transit mileage. At the second stakeholder meeting, a long-standing motorhome dealer joined the group and provided significantly more insight into the transit issues and also into a titling problem to be discussed in a moment. The stakeholders group learned that it was not uncommon for a motorhome to make more than one long journey before it finally ended up in the hands of its first retail owner. It might, for example, be built in the Northeast, be shipped initially to a Florida dealer who would hope to sell the vehicle in the winter season, but who might still have it on the lot as Florida's summer approached and sales of such vehicles dropped. The vehicle then might be taken to a dealer of the same national group of dealerships, but located, say, here in Colorado, incurring a second set of pre-retail transit miles. This process could repeat several times before the vehicle finally was sold to a retail buyer. According to this RV dealer appearing at the stakeholder meeting, this is a recognized feature of the motor home industry, and manufacturers' warranties and other such paperwork are set to begin when the retail sale occurs, not at the point first transit was completed. Therefore, at the conclusion of the second stakeholders meeting, the group agreed that a 5,000 mile threshold could be the optimum bright line for a motorhome, just a motorhome. Now, this is like a legal brief right now, because I've just presented one side of the case. There's another side. Of concern to the aid staff was the question whether the titling provisions found in a sister agency's Title 42, could become an issue between the two divisions if the board created an exception of 5,000 miles for motorhomes, or any exception beyond 1,500 miles, when there was no equivalent exception in Title 42 or in any regulations related to that title. The RV dealer participating in the stakeholder meeting explained that all of the clerks of the counties and the state's titling office had for years recognized through a common practice that this dilemma existed and had apparently allowed the RV dealerships to declare the transits in excess of the Title 42 limit of 1,500 miles. In other words, they had waived their own restriction, but not through a regulation, not through a change of statute, simply as a matter of practice. Now, just a footnote, agencies can do that. They can create what appears to be a regulatory scheme through a practice that they adopt and consistently use. So perhaps they did that. He indicated that they had always allowed, the titling people, had always allowed the dealership's declarations to stand and had allowed the motorhomes to continue to be new for purposes of the initial retail transaction and titling. An unsuccessful effort was made to obtain information directly from the individuals in this building who are involved in the Title 42 procedures. No one answered our inquiries. As a result, the 5,000 miles was implemented in the current draft. But in order to help to allay the fears of potential conflicting requirements between the two state agencies, the staff and AG drafters added paragraph 1 in the draft. And paragraph 1, okay. I want to take a look at that. States, this regulation applies solely to matters within the jurisdiction of the Motor Vehicle Dealer Board. Now, I'm not going to offer a legal opinion on this, but Mr. Jones is here for that purpose, to advise the board on this legal statement and the background of it.
So I'll keep this brief. Based on what Mr. Beebe just shared, this was identified during the stakeholder meetings, and what this regulation does is it solely indicates that this is limited to whatever authority the board has. So that would be anything that falls under Article 20 of Title 44, and then the board's regulation and rules. In other terms, somebody can't use this regulation to benefit them if they're having a dispute with the Division of Motor Vehicles. So this is solely for our purposes, and it's saying if you comply with these regulations, you're not going to have any issues with us. And so that's 1,500 miles for motor vehicles except for those classified as motorhomes, and then anything below 5,000 as proposed for motor homes, or whatever number the board sets. The reason that this is a concern, as Mr. Beebe alluded to, is that under Title 42, which is for certificates of title that falls under the purview of the Division of Motor Vehicles, it defines a new vehicle as any vehicle that has demonstration use that is less than 1,500 miles. So that is the starting point. That's my understanding when this regulation was previously addressed, that's where they got that 1,500 mile number. And as Mr. Beebe mentioned during the stakeholder meeting, we wanted to keep that, but based on the concerns raised by stakeholders, we were carving out an exception for motorhomes, but that is limited solely to our regulations. If the industry representatives have any concerns with that, they're going to have to go to the Division of Motor Vehicles or to the General Assembly to get an appropriate change.
So does that mean that if a RV dealer sells a vehicle with 4,800 miles and a customer to file a complaint with the Auto Industry Division, we would adhere to this rule, but if the vehicle was being titled, the clerk would say, no, this is used. And that the buyer of that motor vehicle would have to accept that definition of used by the clerk? Is that what you're saying?
Yeah, yes, in that hypothetical, if you guys adopted this 5,000, they would be in compliance with our regulations, so there wouldn't be an issue, but they may have an issue with the Division of Motor Vehicles. But again, that's their issue to take up with the Division of Motor Vehicles. But under our regulations, they would be in compliance. We're basically, based on the concerns raised by stakeholders, we're trying to acknowledge that there is an issue and say that if you are under this X amount of miles, you are in compliance. Again, at the outset of Mr. Beebe's overview of what was discussed, the statutory language for the board is clear. You have the authority as the board under the definition of new motor vehicle to designate what is sufficiently low mileage to be considered new for purposes of our statutory framework. And that's what we're saying is we're carving something out, but that's just for purposes of this statutory framework and the board's regulations. So they may have an issue elsewhere, whether it's with another division such as motor vehicles or some other agency, but for our purposes, they would be in compliance.
Thank you, Mr. Jones. I would also just throw in one thing that did get said more than once at the stakeholders meeting around this very matter, which is that the obvious perfect solution to all of this is a legislative solution where, you know, this exception is recognized for this agency and for the other agency. But no one has moved that ball forward, and you know, we have no basis to believe that our agency, our revenue agency, would give us the bill to do that. So most likely, if such were to happen at all, it would have to come from the outside. That is to say, an interested party outside would have to promote through a legislator such a bill to make that change. Like I say, perhaps everyone recognizes that is the perfect solution to this problem. It may not be the practical and immediate solution. Okay. Now, Mr. Jones having been on tap once, I'm going to untap him again in a second here. If you look at paragraph 4 of the proposal, better get it out here. This may seem just too obvious, okay? But we're not being cute here, okay? A, quote, used motor vehicle, end quote, is a motor vehicle that is not a new motor vehicle. There's actually a legal basis for this. Mr. Jones, would you like to share that?
So the whole reason that there's a number of changes that are occurring with this regulation is because in 2016, the Auto Industry Organic Act went through what's called the sunset process, where they review it as the General Assembly. Ms. Rouse and Mr. Zuloff, I think, spent countless hours going through that process and brain cells in trying to formulate better statutory provisions along with all the stakeholders that were involved. As a result of that, there was a definition that was added for new motor vehicle, but there was no definition that was added for used motor vehicle. I don't know why. I don't know why. The curious thing is, as Mr. Heggs and Mr. Beebe have mentioned, we're supposed to look at these motor vehicle regulations in conjunction with the power sports vehicle regulations. Under the power sports framework, under the title, or under Title 44, Article 20, Part 4, there is a definition for new power sports vehicle, and there's a definition for used power sports vehicle. The definition of used power sports vehicle under 4420 402 Paren 19 states used power sports vehicle means a power sports vehicle that is not a new power sports vehicle. So that was the basis of the language that appears in paragraph 4. That is also key because you will notice substantial differences between the proposal for the motor vehicle regulation compared to the power sports regulation. And that is the whole reason that there is a significant difference, other than the fact that there's no motorhome that qualifies as a power sports vehicle. So the only thing that carries over, as was discussed and came out of the stakeholder meetings, is that the regulations are solely limited to the jurisdiction and the authority of the Motor Vehicle Dealer Board, as well as the common reference between manufacturer's statement of origin, which is also commonly referred to as manufacturer's certificate of origin, and then also the definition regarding transferred, as it applies and is listed out in the statutory context. Based on any of that, is there any questions?
That was very helpful because you just took care of a whole paragraph with me.
Great.
Yeah. What I would just add is that these terms of art, we often see them in statutes, and we see a need then to do something in rule to help the public, help the regulated community to stay within the boundaries there. And something that I have run into, which I guess most of the staff had run into at one time or another, was evident through discussion brought up by the stakeholders that this manufacturer's statement of origin and manufacturer's certificate of origin are virtually equivalent, but they just keep coming up in different places in one form or another. So that was why it was important to say these are the same. And transferred, there was a bunch of discussion about that. Because transferred could have a great many unusual bells and whistles associated with it. And unfortunately, if you start putting every bell and every whistle associated with that concept into a rule, all of the exceptions swallow the rule. So you see the simplest, most straightforward way that we could resolve that in the formulation before you. Okay? All right. Now I'm going to do the power sports one then. If you have questions for me, we'll go forward to that. Okay, the power sports parallel rule. It's similar, but in not entirely the same language. You see that. It's very limited. And the staff originally brought to the stakeholders group the theory that there was really no need to have a parallel rule for power sports vehicles. And principally because the large variety of those vehicles don't have odometers or any other technical, mechanical, certain features that would allow, a visible line to be brought to attention for any one vehicle as to what was new or used. They each would have been their own little universe. And that seemed highly problematic to do. The power sports industry representative agreed initially that there was no need. But then shortly thereafter, with some additional thought, came back to us and said, well, maybe we better do something because of these concepts of this, the terms of art. Those things do matter. Let's make sure. And, to bring a little more into focus, just so you know, everyone recognized that power sports now had a titling aspect to it after the last two terms of the legislature. But those are new aspects, and it was very premature for this board, we felt, to start considering what this board would need to do reflecting those matters, if there would be anything. So the language that you see is principally what the power sports representative identified as important, and which, as Mr. Jones has said, was important to put in, and it's there for that reason.
And I'll just take this moment to draw the difference between new motor vehicle and new power sports vehicle. As I mentioned, new motor vehicle refers to odometer. The definition as laid out in statute for a new power sports vehicle means a power sports vehicle that has been transferred on a manufacturer's statement of origin and for which an ownership registration card has been submitted by the original owner to the power sports vehicle manufacturer. And so that's the distinction between the two.
Do any board members have questions for Mr. Jones or for me? Now, you'll have your deliberation later. This is your chance to push on this issue. Okay. So let's move to segment 2. Okay, segment 2 involves motor vehicle rule number 44-20-102, parent 28. And this is a proposed deletion of the rule. And with regard to the power sports side, there is no current power sports rule in existence. And at this point, the staff is proposing none. Okay, so in this Group 2 set of rules appear all the current rules related to wholesaler activities. Now, I'm talking about this whole group of rules that we're dealing with. The design of that, bringing all those rules in at once, is there weren't many, and it was time to look at all of them. Because the effort is being made to package these things efficiently for the future, and these packages as they existed were not necessarily the best packages. So this rule pair involves solely a motor vehicle version in the current board regulations. The division has proposed that the current rule, 44-2102-28, be merged with 44-20-108, parent 1, parent E. So effectively, it disappears. However, the combined rule places most of the significant content of the deleted rule into the new rule. So it's just a way of repackaging for efficiency, reducing the number of rules in that process. Now, a combined rule is in general more efficient, effective, clear, and enforceable as a regulation because it is a good package. Both of the authorizing statutes, and I mean the two that are present supporting the two existing rules today, would become authority for the combined rule. There's no loss. The authority is there. It just goes to one rule. This consolidation is forward-looking, as the board will soon consider the complete recodification of its rules from what we have now, which is the statute number-based rule naming convention, to a topical convention. And you've heard this addressed a couple times in different meetings and things, but the concept is just that we want to get modern, and the modern way is to have blocks of rules under topics, easily accessed by the public, easily accessed by anyone in the regulated community, and get rid of this very complex combined problem that we have right now, where we name the rule after a statute that is not necessarily the only one that matters, okay? But the one that is the apparent parent. So this is an example of a consolidation looking in the direction of a future moment where the topical formulation will exist. Therefore, the initial staff draft brought to the stakeholders group incorporated this concept. The stakeholders group agreed that this was a sensible approach. Therefore, it was a consensus without debate that this rule, section 44-20-102-28, could be deleted. And I might say, it's almost never a good idea to formulate a rule under a statutory definition, much less a multi-part rule, because some people could have questioned, well, why did we move it in this direction instead of that direction? And the answer is, you don't want to have a whole lot of structure underneath a definition. You want it under a more operative part of the statutory scheme when you can. Okay. So this matter, after the initial stakeholder meeting, did not become a matter of discussion later. Okay, now, needless to say, no power sports rule exists, and if the board chooses to delete an existing rule in motor vehicles, there would be absolutely no sense to creating one in power sports, okay? Any questions? That one was the easy one. Okay, turning to segment 3. Segment 3 concerns Motor Vehicle Rule number 44-20-108, parent 1, parent E, down from there, and Power Sports Vehicle Rule 44-20-408, parent 1, parent F, which is a proposed new parallel rule. So now we are to the wholesaler consolidation rule. Okay, so looking at the motor vehicle rule, paragraph by paragraph. Paragraph 1 is not a new concept, but it's a new formulation of an existing concept in order to capture the existence of a variety of possible business structures for a wholesaler. I mean, it should be self-evident that we don't restrict a wholesaler to being just a sole proprietor or just a traditional corporation. They can be any structural form of business that they choose and be licensed as a wholesaler. That recognizes that. Paragraph 2 is also not a new concept, but it's written in the language of mandate. That is the shall not language, rather than written permissively as may not. This reflects the modern requirement that the helping verb, whether it's shall or may, has to reflect the actual intent of the regulating agency. Here, the actual intent was always a prohibition, not a permission. So it had to be fixed. Paragraph 3 is a mere reformulation of earlier provisions into a modern structure. Pardon me. Paragraph 4 is also a modern formulation in which the preferred language approaches to comprehend as best possible the entirety of the obligation within the authorizing statute's own language. That eliminates the scope problem entirely. There's an irony to this. Occasionally, you have a situation where you don't have a completely adequate statute to approach the regulatory nature of your environment. But you may have a part of that statute that speaks for itself and works well. If you absolutely want to make sure that it is consistent, you can restate it. And that's what this does. So there's no scope issue at all. Paragraph 5 utilizes modern language formulation to better clarify the separation between the requirement that a wholesaler acts solely in its own name and never in the name of another person. Person is a defined term in the board's statutes. It's defined as, okay, quote, person means any natural person, estate, trust, limited liability company, partnership, association, corporation, or other legal entity, including a registered limited liability partnership. The board does not require a wholesaler to be structured in any one type of business. Therefore, for example, a traditional corporation, let's call it Best in the West Incorporated, could be licensed under the DBA, quote, Best in the West. And that corporation could be 51% owned by a natural person. We'll call him Johnny Best. And 49% owned by a liability company with the name, quote, Best Western Enterprises, LLC. Under the proposed revision of the rule, all wholesale business transactions would have to go under the name of the wholesaler, Best in the West, Inc., and none of them could go under the name of Johnny Best, Best Western Enterprises LLC, or any other person's name. That is, not under Johnny's spouse's name, or one of the Best children, etc. The reason for this prohibition has not changed from the current rule, but the modern formulation addresses better the myriad of circumstances that need to be considered. This is an area of great mischief, folks. There are a lot of ways that this could play out in a regulatory environment in the negative. So this is trying to prevent that from happening by really stating it clearly. Paragraph 6 is designed to parallel the record inspection, record provision without a subpoena, and record provision with a subpoena provisions that now exist in the record production and inspection regulations for motor vehicle dealers and used motor vehicle dealers. It is the staff's opinion that there is no principled basis to differentiate among types of dealers with respect to these requirements. In other words, you can't treat wholesalers differently than you treat used or new motor vehicle dealers with regard to record inspection and these other things, okay? Additionally, to set up a difference between wholesalers and other types of dealers in this context would produce costly and likely unwinnable equal protection challenges, provided the two sets of rules actually pass the scrutiny of the Office of Legislative Legal Services constitutional review. And, you know, it's just sensible to have everything consistent in this arena. Paragraph 7 retains the use of the defined terms for profit and, quote, gain of money as references to an existing rule. That rule hasn't been reviewed for a very long time, folks. It is not on the table right now, but at some point the division may, this next year or after that, undertake review of these fundamental business terms. Currently, it seems essential to retain the reference. And then the power sports rule is a full parallel because there's no principled basis for it not to be. Are there any questions here about this wholesaler rule? Just as a footnote, wholesalers were invited and they saw all this and did not add any challenge to any of it. Segment 4.
I have a question.
Oh, sure. Sorry, sir.
I don't know if this is the right time. Like in paragraph 4, it says a wholesaler shall maintain written records of all business transactions.
Yes.
You're talking about wording and verb. Is that word written going to be an issue? Written to me means written ink, paper. Is computer sufficient, or do we need to look at that, or does that matter in legal language?
So
I don't know.
there was discussion because we said records, and there was a little bit of pushback, and they requested that it be written. And basically how we were viewing that is any written offer, whether it's by email or by letter or whatever, that pertains to a sale, exchange, or offer of any interest in a motor vehicle. Does that answer your question? So if they're making any type of offer that is in writing pertaining to a sale, exchange, or offer of a vehicle, then they should retain it.
So you're saying that any written offer, if the customer emails the dealer and says, what's your best price? And you say, hey, if you come in today by 5, I'll sell this for $5,000. And the guy never comes in, that email should be printed and retained as a record?
No, this is if the business and correct me if I'm wrong, it's if the transaction actually goes through.
Right.
Because that's what the division it cares about, is tracking these vehicles that a wholesaler is involved in purchasing and then selling to another wholesaler or to a motor vehicle dealer or a used motor vehicle dealer. And so they need to retain their documents concerning whatever transaction, whether that's a purchase or a sale pertaining to that vehicle. But if it's an offer that doesn't go through, that really doesn't come up that much, my understanding is. And
Yeah, and you know, here, you've raised the issue of the electronic paradigm, essentially. And one can find a different language or a set of words in combination that embraces the traditional written paradigm and electronic. I think it would be safe to say that the auto industry division has, more than any other division I'm aware of in state government, addressed issues related to the electronic paradigm. And it would be highly unlikely that, you know, a communication that fit within the electronic paradigm solely, as in a transaction by email to email, whatever, if it were concluded in a way that would fit under the normal transaction, say, between dealers, under the Uniform Commercial Code, it'd be really unlikely that that would be looked at as not being a quote writing, you know, when in almost every other part of state government it would be. So, you know, I'm happy you raised the question. I'm not sure that we have the exact wording to change it if we needed to, but I don't think we need to.
well, let me tell you this, during the stakeholder meeting, this came up, and there was actually proposed language, and you can see this on page 109 of the record, where, based on the requests of the stakeholders, we took out the language, attempt to negotiate a sale, lease, or exchange, because that was feedback we received from the stakeholders and the concerns regarding just offers that were made that were never followed up on, or attempts by the wholesalers themselves to engage in a sale, exchange, or offer of some sort. That never went through. Any other questions?
No.
I guess this brings us to segment 4.
Yes.
Yeah, thank you. This involves Motor Vehicle Rule 44-20-108, Parent 1, Parent H. And this is a proposed deletion of the rule. And there's no power sports rule in existence and none is proposed. Okay, the staff reviewed this rule with respect to the existing language of the statute and did not see a basis to continue the rule in existence. There's no history of problems around the issue of bilateral insurance or bilateral guarantees for selling dealers and buying dealers and Colorado's licensed wholesale motor vehicle auction dealers. The wholesale motor vehicle auction dealer community was made aware of this rule proposal and of the review and this timely awareness, and were specifically offered the opportunity to appear at the stakeholders group meetings. They did not appear. Now, I don't know if there's any of them in the audience today.
No.
I don't think so. Okay. The other stakeholders present at the meetings, the new and used car dealership community, expressed no concerns with this change. And of course, there's no power sports rule because there are no licensees of that license class in power sports. So we couldn't even begin to fashion a rule there. So this is just a pure deletion, and this is one of those cases where the statute can stand for itself. Okay. Any questions on that? Segment 5. This is Motor Vehicle Rule 44-20-109, Parent 2, a proposed revision, and Power Sports Vehicle Rule number 44-20-4092, also a proposed revision of the parallel rule. Now, the proposed revisions to this rule have been made for the following reasons. 1. In last year's rulemaking, the board adopted a complete and detailed revision of the provisions for dealers in this state to to obtain off-premise sales permits. The staff consciously paralleled the revision of the existing rule here to the now existing off-premises sales permits requirements wherever such parallels could be established. This was done to ensure that the process for both out-of-state dealers and in-state dealers was consistent wherever it could be. Clarity of the term, quote, out-of-state motor vehicle dealer was deemed to be essential in this rewrite. Paragraph 1 of this proposed draft deals with that definition. Now, we're saying a merely non-resident person or entity is not sufficient to qualify the uniqueness of the entity type for this rule. The board licenses many non-resident entities as dealers in Colorado, and they would not be qualified for this unique designation. However, a non-resident dealer that is also not licensed otherwise in Colorado as a dealer does capture this category. Paragraph 3 was added at the request of a stakeholder to make a very important exemption for out-of-state motor vehicle dealers coming in to the auction houses in Colorado.
It's paragraph 2.
Or paragraph 2. Yeah, sorry. I wrote this at midnight. Okay, and the only purpose they're coming in is to buy a vehicle at that auction. They don't belong in this category where they would have to seek a permit to appear at such a function as a normal wholesale auction at a licensed Colorado wholesale auction dealer. That's why that was put in. Now, the traditional limited list of possible events was retained, but with a slight revision because it appeared that one of the events had changed its official name. This will happen. The staff has also become aware that at least one out-of-state dealer, a dealer in ambulances, would like to be able to attend an ambulance-related larger event that transpires annually in Colorado. Under the current regulation, there is no provision for that dealer or for any other dealer who may be able to identify any other regularly occurring event to obtain the board's permission to attend that event, because that event wouldn't be on the current limited 3 list. Therefore, the staff laid out a process by which the board would preliminarily review a petition by an out-of-state dealer to be able to attend a specific event that isn't on that 3-numbered list. The petition was visualized as its own separate document that would be advanced to the board at least 90 days before the non-listed event, and that would provide sufficient information as part of the petition for the board to rule on the event without recourse to any hearing. It was felt that it would be extremely burdensome to add another hearing to the board's world simply to deal with this, and when you could receive adequate information right up front to make a decision. Now, clearly, if you made a decision that somebody didn't like, they could go ahead and do something about it. But that would be an appeal. The board could turn the petition down or could authorize the event for the petitioning out-of-state dealer. In the latter case, that out-of-state dealer would still have to follow through with all the requirements otherwise set out in the rule before it could obtain the actual license to appear and sell at the event. It's just an extra step that would help, to open the door a little more. Most of the other provisions were modified from the original rule for the reasons given above for the modernization and review of all, language and rules. And the stakeholders did approve of this language. There is a parallel power sports version. There did not appear to be a principal basis to treat a revision there differently. so they are retained in parallel form.
That's not accurate.
Oh, wait a minute.
There's
Oh, that's
no
right.
paragraph 2 because
Ah.
there's no motor vehicle auction dealer.
Right,
in paragraph
that's right.
two.
Sorry.
The question in paragraph 4, and it's just on wording, it says the out-of-state motor vehicle dealer must obtain the board's permission to apply for a temporary license. That makes it sound like we have to give them permission just to apply, and then they have to apply. Is
That's
that
correct.
Yes.
Okay.
Yeah, it's a two-step process
Okay.
for someone who wants a different event than one of the 3 events that are already in the rule. So that's that, to give a different opportunity. And I apologize, I just totally spaced the change that he just pointed out.
I had a question on paragraph 1 when defining out-of-state motor vehicle dealer. It's not explicitly said here, and maybe it doesn't need to be, but my impression is that an out-of-state motor vehicle dealer is licensed in another state. Is that accurate, or do they not have to be licensed in another
They
state?
might not have to be.
Okay, so,
Depends on the state.
okay. Do we know how many states is there now licensing? Do we know? I mean, is it a
I'd
lot?
have to defer to.
I don't need an exact number, I'm just curious
We'll,
if.
I don't know if anyone knows.
Right now, currently, I would say 50 states and the District of Columbia and Puerto Rico all require dealers to be licensed. They don't all necessarily require wholesalers to be licensed. They don't necessarily require salespeople to be licensed. I mean, there's some differentiation there, but as far as your standard franchise motor vehicle dealer or used motor vehicle dealer, I'm pretty sure all 50 states still require it, but not for wholesalers. In Indiana, they don't allow, wholesalers to have a wholesaler license. They did away with that because they had some problems a couple years back. So there are some nuances in different states, so I think this way it probably captures it best, that if we put, that they must be licensed in another state, which they can't do because there's no such thing, we'd be restricting somebody who isn't even one of our licensees to something that they can't comply with because their state doesn't necessarily license wholesalers
Okay.
And
or dealers.
oh, sorry. Were you done?
Yeah, I'm done now.
Okay. 2 things. We don't see very many of these applications, okay? Let's just start with that. A couple a year.
Mm-mm.
One.
One a year.
Lately, 1. Okay,
1 in 4 years.
okay.
So,
So,
did the research this morning, 1 in 4 years.
so it's not a biggie.
Yeah.
And whether we will now see 2, because the ambulance business that specifically talked to us about this, that's likely. We'll probably see that, yeah. And to follow up on sort of close the door on this question of the word license not being there for this. Anytime we set up a barrier that looks like a requirement that some other state might not have. So let's just pretend maybe now all 50 states and the District of Columbia and Puerto Rico and Guam, etc., all require dealer licenses. Well, one of those states next year decides not to have it anymore. Okay? Suddenly, we have set up a barrier for someone in that state who no longer had to have a license. They can't come here and do anything, but they could in their own state. Not a good thing.
Right.
So the generality was just, let's not worry about that word, license.
Yeah, I guess my question I saw seemed broad. If I live in Kansas and I'm a sole proprietor, I could say, per the definition, I'm a out-of-state motor vehicle dealer, but I might not, But assuming that we could deny that application another step in the process, I have no issue with it, obviously.
Yeah.
But
Okay.
Any other questions?
Six. Yeah, I don't, just want to make sure that I don't leave something.
Mr. Beebe, Mr. Higgs, we're at segment 6. There's 2 more segments. We're at an hour and a half here. So I need to know how much more time Mr. Beebe, you think you need for presentation of 6 and 7 versus
Very little.
given the board's, given a break to the board. So,
Extremely little.
okay?
I won't say these are easy, because that would be kind of editorializing, but they're easier. Okay, segment 6, motor vehicle rule 4420-110 is a proposed revision of the rule, and power sports vehicle rule number 4420-410 is a proposed new parallel rule. So, motor vehicle rule 4420-110, okay, the proposed revisions are for the following reasons. The current rule deals only with the salesperson license posting provisions of the authorizing statute. However, the staff believes that the posting of any license issued by the board that is relevant to the business of the licensee is actually covered in the statute and should be part of this rule. It's only logical. And in practice, in the discussion with the stakeholders, we learned that it's certainly practice for the businesses that are licensed to post their licenses or have them available to see.
Right.
So nobody was real shocked at this idea that, oh, really? You mean we didn't have a rule that required us to do that? But they were doing it anyway. So this is just placing that requirement on any licensee. Okay. Then, although the term posted may have captured the paper paradigm process standard for centuries, it doesn't any longer capture everything. And the modern state of art includes not only paper posting of notices and other documents, but also includes the electronic paradigm posting methodologies. For that reason, the word display seems to capture both methodologies. The critical matter is that the display be readily visible or readily accessible to the public. Okay, so the stakeholders group agreed with this formulation. There was no power sports version. Everyone agreed that one is needed to be a complete parallel to the motor vehicle group.
And conspicuously display is language that comes directly from the statute, and that's why it was used, and that was discussed during the stakeholder meetings.
Okay, segment 7. Motor vehicle rule 4421-20 is a proposed revision of the rule, and power sports vehicle rule 4420-419, parent 1 is a proposed new parallel rule. Looking at 4420-120, the revisions here are proposed for the following reasons. It's important to capture the process of licensing applications and ongoing license requirements in a coherent, unified rule. These requirements are consistent with division practice and other rules adopted by the board in the last 2 years. There was a conscious attempt here to make this fit within the other licensing practices that have been established by rule. It is important to address not only the original and ongoing sanitary facilities requirements for each place of business of a dealer or used dealer, but also to address the initial and ongoing requirement of the continuing right of the dealer to occupy the places of its business, as well as the dealer's continuing possession of those premises. It's a requirement that, right up front, when we license someone, they have to show us they've got the right to be in the place where they're going to sell cars or sell whatever. And there should be no lapse in that as time passes. We just have not had the formulation there to make clear that that's true. And then, possession is important. I mean, having it there, but not being there and occupying the premises is kind of an abandonment, or could be. So, it's a way to formalize that requirement as a continuing requirement. Obviously, there's ways out of that requirement. You give notice. Okay, the sanitary facilities definition needed modernization and clarification. Everybody had a lot of fun with that definition. And, when finally all was said and done, we realized that just because our modern model sitting in a, big city like this makes some of that laughable, does not mean it's not real to dealers outside of this city, in rural areas, for example, okay? So it's still valid. All right. The stakeholders group agreed these reformulations provide better clarity and consistency for the industry. And then the completely parallel regulation needs to exist because there's no principal basis for power sports to be treated differently. Questions? Nobody want to talk about electronic voting? Thank you very much. That concludes the basic presentation. Do we want to let them have a break and come back, and if they have questions at the end of the break?
Yep.
Okay.
Take a break.
All right.
How long? 10 minutes?
10 minutes. So do I need to announce the time?
Yeah.
Yes. So the time is, I guess it'd be 10:45. And we'll begin. So the division has finished its presentation of the record, and it's time to hear comments from the public. If anyone in the audience has not signed our sign-in sheet, please do so now. I do have it up here. Okay. If any, okay. So I guess with that, based on the number of people we have that indicated that they want to address the board, it's not necessary to limit time for each person to speak. Please make your comments as succinct as possible. If anyone has additional documents they want to provide to the board, please hold up your hand. Seeing none. It appears that there's no documents anyone wants to add to the record. Each person who wants to be heard will be heard in the order of signature on the attendance sheet. Therefore, would Mr. O'Connell please come forward to address the board?
Morning, I'm Tom O'Connell, CEO of the Colorado Independent Automobile Dealers Association. Thanks again for your time here. I'd like to again commend the Auto Industry Division and their staff for the process of the rulemaking, the stakeholder meetings with the basis of the new rules and regulations is a tremendous help in not having to start from scratch. They do a marvelous job in structuring the program. Obviously, Mr. Leland going through the rules. That's how the stakeholders meeting is run, very, very efficient. And just want to put on the record that CIADA supports the current proposals. We did have a few changes in the stakeholder meetings, but they've all been reflected and addressed satisfactorily. So we're here to support. That's all I have, unless there's questions. Thank you very much.
Thank you.
If there is anyone else from the public who would like to address the board regarding the set of rules being considered today, seeing none, we'll turn it back over to Mr. Beebe. Does the division have any further comments it wants to make at this time with regard to the rules being considered today?
No, none.
Okay, and now my question for the board members, do you have any questions for Mr. O'Connell or Mr. Beebe or myself at this time before we enter into the deliberation stage?
I guess I have one question that was brought up about the odometer limits earlier. So just correct me if I'm wrong here, there is no, because I know power sports can still have hour gauges. There's no limits on those currently at all?
No.
Okay. Has it ever been discussed or?
Yes.
Okay.
The power sports industry is well aware of this, and there are no national standards. Let's start there. Okay, there are national standard groups, SVIA, ANSI groups that are involved in these processes. None of it's ever happened. There may be going into the future because of these title matters now coming forward, but right now, no.
And that was something that was discussed during the first stakeholders meeting, I believe. So, Any other questions?
Good. All right. We've reached the conclusion of the public comment phase of the rulemaking hearing. I'd like to thank everyone who has participated in this process today and everyone who has otherwise participated in the rulemaking process to date for all of their input and hard work. This time I'd like to call for a motion to close the public comment phase of the hearing to consider proposed rule revisions, proposed deletions, and proposed new rules related to both 1 CCR 205-1 regarding motor vehicles and 1 CCR 205-2 regarding power sports vehicles. Is there a motion to close the public comment phase of the rulemaking hearing?
I, Michael Whithelm, hereby move that the board close the comment phase of the rulemaking hearing on the proposed new and revised rules and proposed deletion of current rules that were given public notice by publication in the Colorado Register, Volume 41, Number 18, on September 25th, 2018, under tracking numbers 2018-00474 and 2018-00475, and as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
Is there a second?
I'll second.
Second by Mrs. Baumgart. Is there any discussion? All in favor? Passes unanimously. The public comment phase of the rulemaking hearing is now closed. No further comments from the public or the division will be allowed without explicit recognition by the chairman. The board will now begin the deliberation phase of the rulemaking hearing. The deliberation phase is open to the public, but only board members and the Attorney General representative are permitted to participate. It is important that everyone remain silent during the board's deliberations. If you have not already done so, please turn off your cell phones. The deliberation phase will take place in distinct segments. Each segment will involve the board's discussion and determination on the rule or rules making up the particular segment. At the conclusion of a segment, the board will vote on the rule or rules comprising that segment. If more than one rule is in the segment, a separate motion and vote will occur for each rule. Today's hearing includes both motor vehicle-related rules and power sports vehicle-related rules. Many of these are parallel rules to one another. Therefore, the board's tradition to ensure efficient discussion and consistent formulation of language wherever possible, some segments in today's deliberations will incorporate deliberations on both a motor vehicle-related rule and its parallel power sports vehicle-related rule. If a rule is unique to motor vehicles or to power sports vehicles, it will be the only rule in a given segment. The board members will have in front of them a packet for each segment. Included in that packet will be a current version of each rule in the packet, the redline version showing the changes proposed for each rule in the packet, and the clean version showing how the rule would look if the proposed changes were all adopted. The materials in each package are extracts of relevant pages in the record for the board under headings A and B. For the board's ease of cross-reference to the complete record for board review, page numbers that appear on the documents in each segment's packet match the page numbers in the record. Special statutory reference note. Section L in the record for the board review displays the entire current statutory scheme of the board. Subsections L.1 contains Part 1 of Article 20 of Title 44, CRS regarding motor vehicles, and subsection L.2 contains Part 4 of Article 20 of Title 44 CRS regarding power sports vehicles. Board members are advised that any question of statutory law, regulatory law, or the relationship between those should be addressed to the Attorney General representative who is present to advise the board on legal matters and to answer legal concerns. Therefore, the deliberations will progress segment by segment as follows. Segment 1, Motor Vehicle Rule Number 44-20-10220.
So now we take that up.
Okay.
So,
Oh, is there a motion?
Discussion, I guess, or motion? No?
Yeah, is there
Yeah, is
discussion
there
or
discussion?
motion?
That's what I'm asking. Is there any discussion anybody has on this? Discussion on it before? My only concern, I guess, for the record is just that the regulation only applies within the jurisdiction of us, and we kind of spoke about that, so.
Okay.
Well, I guess if there's no discussion, I guess I'll make a motion then. I, Michael Whithelm, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-102, parens 20, without any modifications and exactly as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
Do we have a second?
Second.
Second by Mr. Flower. Any further discussion by the board members? All in favor? Passes unanimously.
And I'd like to make a motion for the proposed new rule for power sports in conjunction with that rule. I, Michael Whithelm, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-402, parens 8, without any modifications and exactly as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
Second.
Second by Mr. Linton. Any further discussion? All in favor? Passes unanimously.
Yeah.
Okay. So in segment 2, motor vehicle rule number 44-20-102, paragraph 28, a proposed deletion of the rule. Any discussion or motion?
Discussion.
I'd make a motion then. I, Fletcher Flower, move that the Motor Vehicle Dealer Board adopt the proposed regulation 44-20-102, paren 28. without any-
Sorry to interrupt, but this is a proposed deletion, so I think you would be looking at the final script in the packet, which is under script E.
Okay. Which one is it?
E.
E.
Sorry about that. I, Fletcher Flower, move that the Motor Vehicle Dealer Board delete the current regulation number 44-20-102, paren 28, as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
I'll second.
Okay. Second by Mr. Porter. Any further discussion from the board? Hearing none, all in favor? Passes unanimously. For segment 3, we have motor vehicle rule number 44-20-108. Paragraph 1E, a proposed revision of the rule, and power sports vehicle rule number 44-20-408, paragraph 1F, a proposed new parallel rule. Any discussion from the board members? Hearing none, anyone have a motion?
Guess I'll make a motion. I, Michael Whithelm, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-108, parens 1, parens E, without any modifications and exactly as set out in the record for the board review on this October 25th, 2018 rulemaking hearing.
Second.
Second by Ramona. Any further discussion? All in favor? Passes unanimously.
I'd also like to make a motion for the parallel power sports rule I, Michael Wilhelm, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-408, parents 1, parents F, without any modifications and exactly as set out in the record for board review this October 25th, 2018 rulemaking hearing.
A motion by Mr. Wilhelm. Any seconds? Second by Mr. Porter. Any final comments? All in favor? Passes unanimously. Moving on to segment 4. Motor Vehicle Rule number 44-20-108, paragraph 1HI. A proposed deletion of the rule, and there's no existing rule to delete the power sport rule. I'd like to open it up for discussion from board members on segment 4. Hearing none, do we have a motion?
I'll make a motion. I, Matt Porter, move that the Motor Vehicle Dealer Board delete the current regulation number 44-20-108, parents 1H, as set out in the record for board review on this October 25th, 2018 rulemaking hearing.
I'll second.
A second by Mr. Flower. Any final or further discussion from the board?
I just had a question. Is it 1HI or 1H? Different. Does it matter?
Could you repeat that question?
I think the motion was for 108, parents 1, parents H, which is what it says on the front of the packet, but then I believe what Mr. Haig said, and also the actual regulation is parents 1, parents H, parents I.
That's correct.
Okay, so is that the motion then?
So just to clarify, Mr. Porter, you were moving for the deletion of the current regulation 44-20-108, paren 1, paren H, paren Roman numeral I.
That's correct.
And that was seconded by Mr. Flower, is that correct?
That's correct.
Okay.
Thanks, Mr. Blankman. Any final comments, further discussion? All in favor? Passes unanimously. Segment 5, Motor Vehicle Rule number 44-20-109, paragraph 2, a proposed revision of the rule, and Power Sports Vehicle Rule number 44-20-409, paragraph 2, a proposed revision of the rule. Any comments or questions from the board members?
I'll make a motion. I, Fletcher Flower, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-109, paren 2, without any modifications, and is exactly set out in record for the board review for this October 25th, 2018 rulemaking hearing.
Motion by Mr. Flower, a second by Mr. Porter. Any final comments or further discussion items from the board members? Hearing none, all in favor? Passes unanimously. Mr. Flower, would you also like to make a motion with regard to this power sports rule?
Yes. I, Fletcher Flower, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-409, paren 2, without any modifications and exactly as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
A motion by Mr. Flower, a second by Mr. Porter. Any final thoughts, questions from the board members? All in favor? Passes unanimously. Segment 6, Motor Vehicle Rule number 44-20-110, a proposed revision of the rule, and Power Sports Vehicle Rule number 44-20-410, a proposed new parallel rule. We'll open it up to any comments, questions, or other discussion items from the board. Hearing none, would someone like to make a motion?
I'll make a motion. I, Carrie Baumgart, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-110 without any modification and exactly as set out in the record for the board review this October 25th, 2018 rulemaking hearing.
We got a motion by Mrs. Baumgart.
Second.
Second by, got 2 seconds.
Oh.
Mr. Wall and by Ramona. Any further final thoughts or discussion matters from the board?
So just to make the record clear, it was Mr. Welltown that made the second first. So.
First.
He seconded it.
Like a bronze trophy.
Yeah.
I paused, so I kind of played big shout. Yep. Yep. All in favor? Passes unanimously.
And then I, Carrie Baumgart, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-410 without any modifications and exactly as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
Got a motion by Mrs. Baumgart, second by Mr. Porter. Any final thoughts or questions from the board members? All in favor? Passes unanimously. One more, yep. Segment 7. Motor Vehicle Rule number 44-20-120, a proposed revision of the rule, and Power Sports Vehicle Rule number 44-20-419, paragraph 1, a proposed revision of the rule. Any comments, questions, observations from the board?
I think it was a revision of the motor vehicle rule and the creation of a new parallel rule for power sports.
Correct. Our script has it wrong. So apologize.
Yep. Would someone like to make a motion?
I guess I'll make a motion then. I, Michael Whitnell, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-120 without any modifications and exactly as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
Got a motion by Mr. Lehone, second by Ramona. Any further discussion, comment? All in favor? Passes unanimously.
All right, I'd also like to make a motion for the new parallel regulation as well. I, Michael Whitnell, move that the Motor Vehicle Dealer Board adopt the proposed regulation number 44-20-419, parent 1, without any modifications and exactly as set out in the record for board review for this October 25th, 2018 rulemaking hearing.
A motion by Mr. Wiltown, second by Mr. Porter. Any final discussion items from the board? Seeing none, all in favor? Passes unanimously. So we've reached the conclusion of the entire rulemaking hearing. I'd like to thank the board members and everyone else who participated in this process today. This time I'd like to call for a motion to close the hearing. Is there a motion to close the rulemaking hearing?
I'll make that motion.
Motion from Ramona, is there a second? Oh, sorry.
I, Ramona Vogt, as a member of the Motor Vehicle Dealer Board pursuant to the authority of the board in Colorado Revised Statutes, sections 44-20-104, parentheses 3, parentheses A, and 44-20-404, parentheses 1, parentheses A, to promulgate, amend, and repeal rules pursuant to the provisions and procedures in the arising from Colorado Revised Statutes Sections 24-4-103, and move that the board close the rulemaking hearing on the proposed new and revised rules and the proposed deletions of current rules that were given public notice of publication in the Colorado Register, Volume 41, Number 18, on September 25th, 2018. Under tracking numbers 2018-00474
and 2018-00475, and is set out in the record for board review for this October 25th, 2018 rulemaking hearing.
Is there a second? A second by Mr. Porter. Any further discussion from the board? All in favor? Passes unanimously. So the motion to close the rulemaking hearing passes unanimously. I declare this rulemaking hearing closed.
Good job, Mr.